Do you want to say?
Lest I forget.
We have prepared a handbook on combating gender stereotypes to assist judges and the legal community in identifying, understanding, and combating stereotypes about women in legal discourse. It contains a glossary of gender unjust terms and suggests alternative words or phrases which may be used while drafting pleadings as well as orders and judgments. So it reaches out to lawyers as well as judges. The handbook identifies common stereotypes about women, many of which have been utilized by courts in the past, and demonstrates why they are inaccurate and how they may distort the application of the law. The intention is not to criticize or cast doubt on past judgments, but merely to show how stereotypes may unwittingly be employed. To raise awareness against the utilization of harmful stereotypes, particularly those prejudicial to women, the handbook aims to explain what stereotypes are and helps judges identify and avoid such stereotypes by firstly identifying language that promotes gender stereotypes and offering alternative words and phrases. Two, identifying common reasoning patterns that are based on gender stereotypes, particularly about women, and discussing why they are incorrect. And three, highlighting binding decisions of the Supreme Court of India that have rejected these stereotypes and can be utilized by judges to dispel gender stereotypes. So it's been you have the first page of the document here on the screen, and it's uploaded. It will be uploaded very shortly in a minute or two on the website of the Supreme Court of India. We have also uploaded on the website right now the manual and FAQs for e-filing. And in a couple of days, we'll be also uploading simple video tutorials on how to do e-filing for members of the bar who just require a little bit of hand-holding on that. So that's all. It should be here on the website in a minute now, or a few minutes. Thank you. Thank you, Dr. Goswami. Yes. No, but Mr. Dwivedi, if you start using it, you'll find it so simple actually.
But now we find hampered because of the potential. Because certain things that have come up, I feel may not have been adequately answered.
Please do answer them in your submissions. No difficulty.
It requires addition.
No, addition, you know. So we are making notes, so you can always make the addition in your oral arguments. You know, Mr. Sorry. You know, Mr. Dwivedi, I'll give you a concrete example. I'm in the process of sort of formulating a judgment. We are still, now it's almost done, on Hindu law as to whether a child born from a voidable marriage is entitled to a share in the ancestral property. So today, I mean, over the last few days, I've opened the file. We didn't have any such limit as we have now imposed here. 3 or 4 written submissions by each member of the bar, 3 or 4 compilations by each member of the bar. It's impossible to sit down to dictate a judgment because, you have judgments of different genres and different submissions coming up, and it becomes impossible for the judges to write judgments. So today in the morning, I was telling my secretary, I said, we first need to now look at all the judgments, prepare a separate file, put them in chronological order. But even then it doesn't help because you have marked what was being read out by the lawyer. So, this is the real problem which we face.
There are 2 issues. Judicial precedents were never in such large volumes as it is available today. Go back 10 years even. Number 2, the concept of giving written synopsis was comparatively not there. Everything used to be argued. We used to take down notes and dictate. Now, the purpose of a submission or a synopsis, as I understand, is to facilitate in dictating the judgment. Instead of that, it becomes so much more cumbersome that we don't know who is saying what where. These kind of pleadings of thousands of pages used to not be filed earlier. So that's, there are many cases of this category. No.
No.
At rethinking, they are certain.
Trivedi, my take on this has been, if the homework in the office is thoroughly done, normally this problem doesn't arise.
Can never be complete.
It is possible to do.
The judgment can never be complete. The judgment can never be complete. That thought process will continue from your
And
side,
you know that-
it will continue from our side.
My fear always as a judge is that in this process, I've missed out some very important point of judgment because it's all, sort of placed in different silos. That's what is really worrying for us as judges. This about reading, trying and collating can always do that. Can tell our law clerks to put all the judgments together in a chronological order. Danger is you feel that, oh my God, I might have just missed something because things come in, driblets over a period of time. Supreme Court gives 30 minutes time and 1 hour's time. So we need to now
How does
just.
the US Supreme Court do it in 30 minutes? The most complicated case, they only hear you for 30 minutes, including time interventions of the court.
No, we are far more advanced technologically. Actually, trust me, we are almost at the high end of the curve in India.
Part of habit action.
Yes. So that we can just keep it on the dais, as the hearing. That will be very useful. Naika Bhushan. Just like you want to refer to them. Again, referred to. That's very useful. Oh, you have also put it in a plastic. Oh, excellent. Yes, Dr. Bala.
No library talk this time, my lord. But start again, my lord. I appear for the JK People's Conference, my lord, in writ petition 1165 of 2019. A question that your lordship put to Mr. Sibal was, have you challenged the presidential proclamation of 19th December? We've challenged the suspension, my lord, and that is very important to our argument on Article 3. There is also another petition, my lord, Sohail Qureshi 1068 of 2019, which actually challenges the proclamation.
2068, right?
1068.
Yes.
Now, my lords, I would begin by saying, as well from my lord the Chief Justice, that this oral submission is in the nature of a dialogue, and a very important dialogue, which even the US Supreme Court doesn't have. They assume everything is read and there's a bit of question and answer and that's it. And it is because of the nature of the dialogue, we have to, on an ongoing basis, answer what fell from your lordships as well. I'll give your lordships an example. My lord, the Chief Justice made a reference to 249 and 252. Of course, they are of a different genre. But nevertheless, my lord, that question is very, very important for us to build the diversity argument and whether there is transformative constitutionalism, whether there is a basic structure, whether that's a lost cause or not. Then, my lord, your lordships had asked questions about Article 3(1)(d) and whether Article 370 subclause 3 survives. Now, this is important because it's been used only twice. It was used in GO 44, my lord, And now it has been used once again in GO 273. Now, if it doesn't survive, my lord, how can it be used in this particular way? We have to answer that question for your lordships. In addition to that, my lord, there seems to have been some confusion or misunderstanding on the status of merger agreements, my lord. The question that fell from your lordships was that once the instrument of accession is over, sovereignty is complete. Our respectful submission, my lord, on this, which I will elaborate. I've done it in a note, my lord. Like Mr. Zafar, I'll hand over that note, my lord, to your lordships. My lord, 3.7, as far as the instrument of accession is concerned, it deals with external sovereignty. Kindly bear this in mind, it's very important. External sovereignty is lost. With a few exceptions here and there. But internal sovereignty is not lost. That is why in Premchand, they say the monarch was still an absolute monarch. Premnath calls for him. Somewhat the purpose of the standstill agreement was, what system would you have in the meanwhile? The state of the Raja of J&K didn't sign a standstill. The records show there was some toing and froing and eventually, which means he retained all his power. So as far as internal sovereignty is concerned, the standstill was very important.